in the name of Senator Regan and Cummins arising out of committee proceedings. 13 is related. 12A and 13 may be discussed together by agreement. Is that agreed?
Agreed.
Agreed. Senator Regan.
Thank you, Cathaoirleach. This is a matter which I raised at the committee stage, did not put down an amendment because I wanted to hear what the Minister had to say on the matter. This is in relation to when we abolish double jeopardy rule, whether such abolition should be retrospective and prospective. I have considered the matter, the response of the Minister at committee stage, and I think that the amendment which we have now, Fine Gael has now tabled, deals with the concerns raised by the Minister in terms of interference with court decisions and the judiciary. The reference you made and the objections you made to the suggestion of retrospection was principally based on the separation of powers, which I'll come to. I believe that the abolition of this rule can be retrospective or prospective. I think that it is permitted by the European Convention of Human Rights. It is applied in the United Kingdom in its 2003 Act and in other common law jurisdictions such as New South Wales, which has introduced retrospection in abolishing the double jeopardy rule. And I think the fundamental point is that the rule and the change that has been made is procedural change in criminal law. It is not a change in substantive criminal law. Accordingly, in my view, there can be no constitutional or other impediment to applying the abolition of the double jeopardy rule, retrospective or prospective. The UK Law Commission report of March 2001, which is quoted in the balance, the report, the balance in the Criminal Law Review Group report, which was chaired by Gerard Hogan SC, states that there is the spectre of public disquiet, even revulsion, when someone is acquitted of the most serious crimes and new material, such as that person's own admission, points strongly or conclusively to guilt. Such cases may undermine public confidence in the criminal justice system as much as manifestly wrongful convictions. The erosion of that confidence caused by the demonstrable failure of the system to deliver accurate outcomes in various serious cases is at least as important as the failure itself. And in announcing the change in the law in England, the Home Office underlined that point. It is important. The public should have full confidence in the ability of the criminal justice system to deliver justice. And that is the essential point in putting forward this amendment. Now, the balance in the Criminal Law Review Group, clearly there has to be safeguards when we are making this change in the double jeopardy rule. And I just quote some of the excerpts in relation to this matter, where the report states that the review group considers that while strong arguments can be made against general appeals against jury verdicts on the evidence, those arguments do not rule out the desirability of appeals where new or newly discovered facts provide compelling evidence of guilt. The review group stresses that in order to avoid interference with the jury decision on the merits, safeguards would have to be introduced in the form of A, an exacting threshold for the obligation, such as that the evidence is compelling, for example, DNA evidence or a confession to the offence. B, advance judicial approval for the application. And C, setting aside of any acquittal in the state prior to the question of a retrial arising. Now, the report also states that it seems clear that a new trial could not occur in circumstances where there was an extant jury acquittal by a jury in the state or an acquittal by the Special Criminal Court on the merits. The obvious form of mechanism for both avoiding conflict with an extant acquittal and securing advanced judicial approval for the retrial would be, by analogy with the right of the accused to apply for review by the Court of Criminal Appeal of an alleged miscarriage of justice under Section 2 of the Criminal Procedure Act 1993 to provide for a similar procedure to apply for prosecution appeals. So it's talking about mutuality in this situation, that a person convicted can appeal and apply on the basis of a miscarriage of justice under the Criminal Procedure Act 1993, but the DPP cannot. Under such a procedure, the prosecution would apply to the Supreme Court for an order quashing an acquittal in circumstances where, as with an application by the defence to the Court of Criminal Appeal, it is alleged that a new or newly discovered fact shows that there has been a miscarriage of justice, etc. The report, in providing for safeguards, does not suggest that one of those safeguards is that it not be made retrospective, the abolition of the rule. The report goes on to examine the European Convention of Human Rights, Article 2.4 and Protocol 7, and concludes that the review group takes the view that the European Convention on Human Rights would not be breached by a provision along the lines of the United Kingdom legislation, as the Convention allows both appeals against acquittal and the reopening of acquittals following new evidence of a defect in the procedure. And I think that's important because the UK law, as we know, provides for retrospection. The amendment as formulated is formulated in such a way that it is the courts that ultimately decide on the issue of whether a new trial would take place in relation to an acquittal in the past before the Act was amended. And arguments can be advanced as to why that would be unfair or otherwise to a person who has been acquitted. But they are arguments going to the merits of such an application, not to whether there should be an absolute bar on dealing with acquittals before this Act is passed. Now, on the constitutional principles, we discussed that to some extent at committee stage, and the Minister referred to a number of cases. One, Buckley v Attorney General, 1950. Now, that was a case where they generally referred to as the Sinn Féin case, where the Oireachtas attempted to directly interfere in a judicial proceedings. And in the Howard versus Commissioner for Public Works case, where, again, retrospectively powers were being granted by the Oireachtas, which would have affected a case already decided. This case law, I do not believe, is pertinent or on point on this issue. There is no interference with the functions of the judiciary. It is similar to the abolition of the double jeopardy principle itself, rule itself. It is for the courts to decide whether they set aside an acquittal and whether they permit a second trial. Why there should be the distinction between cases which have occurred post this passing of this Act or before is not clear. It is the courts that should ultimately decide on this question, and therefore the issue of the separation of powers